go. All right. Welcome to the September 22nd meeting of the Habeas Standards Work Group. I'm going to share my screen. Maybe. Yes. Can you all see that?
Mm-hmm.
Great. All right. So since our last meeting, I went through and changed some of the things we'd talked about. I moved this up from one of the best practices to the black letter. Always use clear communications and developmentally appropriate language, and the interpreter as needed. We do this. Yes. We pulled some of the repetitive language out of here and added the lawyer must provide the advise the clients of the consequences of prevailing on habeas as well as the consequences of not prevailing. I think we cleared that up a little bit. And then we moved down here. The ability, if any, to amend the initial petition is something that the lawyer should be providing clients information about when it's applicable.
It's always applicable, so you could just say the ability to amend the initial petition. So there's, yeah, it's expected, actually.
Okay, there we go. All right, anything else about any of that we ought to reassess or adjust before we pop back down into what the lawyer should use the initial contact or any contact with the client to do?
You know, just because there's going to be people
phrasing.
with such a variety of background, I believe you might go back up to V1, 6, I guess, and make this a little more specific that if they're, if you're not having advice that communication with people other than lawyers' team is not privileged. Might add one to that or a new one that if you're not using the attorney phone to speak with a client or your team isn't using the attorney phone, the call is recorded and not confidential. All calls and emails are never confidential. A lot of people email prisoners and it's like such a bad practice because it's all completely, it's just not confidential.
Do they do video visits?
No.
Okay.
I mean, they can for like psychiatrists for expert evaluations, like telehealth, but not for a legal team.
Gotcha. What about for just like general public?
I think in some places they have video visits for family.
I just know they put those into the jails right before I stopped practicing to come up here, and it was occasionally problematic.
Yeah.
All right. So with that, this is where we left off. Things you should generally talk to your clients about. Facts surrounding the client's petition, possible witnesses who the lawyer should locate, evidence that should be preserved, specifically video recordings that might be overwritten, or where appropriate, evidence of the client's competence.
Yeah, I think that all looks good.
Okay. Anything you would add to that? Just things you should be aware of at every interaction with your client?
I mean, you can't put everything in. I think you could just say something. I mean, the facts surrounding the client's petition or case is probably, that's, you could just put or case.
Mm-hmm.
I think that covers it. What do you think, Ed?
I don't have anything to add.
Great. Computer. There we go. Thank you. My computer is also having a Monday. Frequency and manner of client contact. Talked about no less than once a month.
Mhm.
Visit in person as often as possible. And then conduct client meetings. We have the cultural sensitivity and developmentally appropriate. In here again, I'm going to take that out since we moved it up top.
Mhm. I think, visits in person are going to be rare with
Mm-hmm.
with clients because often they're in prisons across the state. So I would say like, contacts as much as possible. Then it could reflect what we talked about before of, once during the case, if a visit in person is feasible.
Okay.
I've never had a video visit with a client, so I don't think that's really available. So you might just say attorney calls. I mean, I wouldn't have any other kind of form of communication with a client.
Any other form of communication with client other than calls?
Yeah,
Or
then an attorney call
in-person visits?
on the
Gotcha.
attorney. Yeah.
Okay. So what if we did this? Da, 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 da.
I actually, while it is a goal and it is an absolute requirement in criminal cases, I don't think we like saying if people can meet once in the life of the case, that's optimal. But like, I'm not going to spend 2 days driving to and from Malheur County and an overnight. It's just not. That's unreasonable. And that's over there like on the east side is where most of my clients are. So and I would say maybe a little softer, like if feasible, once during the pendency of the case. See them in person if you can.
How's that?
Yeah, that's
Okay.
great.
This is Jordan. This is going to cover all habeas, not just medical, right?
Right.
Right. Okay. And Tar, would it make a difference if it were, I mean, I guess this is going to go to lawyers with client in the county jail arguing their fact of confinement. Would that make any difference on whether you need to go in and see them in person?
I honestly don't think it does because it's just the argument is the argument and it's going to be something you find in the records, honestly, and that you can talk about with the client. But I don't think it really makes a difference to the case in this context.
Okay. Okay. And then the once a month contact is feasible,
Yeah,
we think?
definitely. I think that's a good goal.
Okay. So that takes us to the end of the client contact section. Just real quick, we covered the black letter standards about you have to be in touch with your client. You have to be in touch with them within 7 days of appointment. Then we covered all the best practice standards. Be clear, communicate in a private setting, sign ROIs during the initial meeting if you can get them. The things we talked about to cover at the initial interview, the things we just talked about today. Is there anything else that we need to add in terms of client communication requirements or good ideas?
I think it's pretty good.
Great.
I don't have any comments.
Right. Ed? You look deep in thought.
Apologies, not about this.
Gotcha. All right. Moving on to the investigation standard. Lawyer has a duty to conduct an independent review of the case, regardless of admissions or statements to the lawyer. Where appropriate, the lawyer should engage in full investigation, which should be conducted as promptly as possible. Include all information, research, discovery necessary to assess the strengths and weaknesses of the case, to prepare the case for hearing, and to best advise the client as to the possible outcomes of the case. Lawyer has the duty to be familiar with the process to request funding for an investigator from OPDC. And if they do not have access to an in-house investigator, and whenever possible, should avoid taking on investigations themselves that could cause them to be a witness in the case. That may need to be clarified a bit.
Mm-hmm.
The lawyer should not knowingly use illegal means to obtain evidence or instruct others to do so.
I think the only section that I would suggest revising is about the witnesses in a case, investigations, that section.
Yep.
But you could just take that out, I think, in this context.
Why is that?
I mean, I guess it's a different kind of investigation. It's not, it's looking at documentary investigation, like, and records. And it's not, I mean, it's looking at, there is some witness investigation too, but it's very limited. It's very unusual. I don't know, Ed, maybe you found that or didn't. But like, I've used my witness on occasion. She makes these like fantastic, like compendiums of the evidence. And I think once, she was called to testify about something. It was just about her document that she had created. But I mean, so I guess in context here, it's just very different, I think, because of what the focus of the investigation is, which is mostly documentary.
Okay. So
I did have an issue come up in a habeas case. It had to do with delivery of legal mail, and it got pretty messy because a corrections officer volunteered like that there was some improprieties about handling illegal mail that did, not what I've seen in any other habeas case, but it did come up.
So the investigator handled the legal mail?
No, so the corrections officer volunteered to the client, like, yeah, you're getting your legal mail. It's already opened by somebody. Here it is. And it was actually Ernest Lynette's son, who at least at the time was a CO at OSP. And he contacted us, and my investigator talked to him, and we both talked to him. He came to us, and then your friend, I can't remember your friend from DOJ's name, Tara, but he came back and said that we contacted a state employee witness without their authorization and need to go through counsel and everything. And he had come to us. And then they went into the court and made it out like it was an impropriety on our part when he had come to us and, and then didn't sign the declaration that he told us that he gave us over the phone and said he'd sign, and it turned into one of those.
Okay.
I mean, I guess my question would be, why would it be a problem for a lawyer or for an investigator to be a witness? That's actually really common.
Oh, it's not a problem for the investigator to be a witness. The caution was for the lawyer to avoid becoming a witness.
Oh, I didn't read it that way.
That could be
For
because
sure. That's
poorly
different
written.
then. That's different.
But if what you're saying is that most of the investigation is not going out and talking to people, then maybe what we need to do is have our black letter investigation. Just the lawyer has to do their document review type investigation into the case and get the documents. And we move the investigator stuff down to the lower level of you have to know how to get an investigator just in case you need to go talk to someone. Would that make sense?
I use investigators on every case, but they're doing primarily document review and some interviewing of the client, and occasionally there might be witnesses. But I completely misread that sentence, and I thought it was about the investigator not being a witness. So
gotcha.
That just changes my comment.
To use the investigators for document review, client contact, and talking with witnesses. Okay. Okay. So I think I will spend some time before our next meeting rewording the bold letter law to be more applicable here. Let's drop down to our best practices bit. Retain an investigator as soon as possible after appointment, I assume applies. Things you should be getting: copies of the petition, the order to show cause, the defendant's response, the writ the court ordered, and lawyers should examine them to determine the specific issues that have been brought, should say, by the client and the elements of each. Conduct an in-depth interview with the client. Use the interview to determine additional sources of information concerning the issues or events giving rise to the petition. What other evidence are you looking for in that first interview with the client?
I go through kind of the big categories of what tends to be subject matter, based on whatever they put in the petition. But then, I go over medical issues. I ask where we might find records, like where they got out of custody care, so we can start thinking about getting those records. I'll ask them about mental health, and the same kind of question: where did you get mental health care? So we can think about getting those records. And then, and my cases are medical, like almost exclusively, which includes mental health, and also I have failure to protect claims as well. So, if I can just kind of flag the big ones that are typically in every case, which is conditions of confinement, medical or mental health, I'll ask as many specifics as I can about that, both where records are and what their diagnoses are, to kind of start getting a handle on where we need to get records and what's going on for the client. I also need to find out when they're going to be released and if they have trans release possible.
Okay. Anything else other than like, name, date of birth, kind of basic fact stuff? Anything else you're looking for?
Well, I give a big spiel about the process of habeas,
Mm-hmm.
first of all, and then talk with them specifically about what they raised. And then that sets off, the next level of asking about what particular records or what the status is of whatever the issue is they raised. But it's kind of really dependent. It's interview dependent on where it's going to go.
Okay.
I'm not sure information about the
Is
jurisdiction would, I don't know how that would come up.
okay. Is jurisdiction ever an issue, or are these all just filed?
It is an issue if they get transferred to another prison.
Mm-hmm.
Then the jurisdiction of the receiving county becomes the new jurisdiction. So that's how it's relevant.
Okay.
But it's not relevant in the way that I think this C contemplates. Um, it's not usually a question whether the court has jurisdiction over the case or not.
Okay. Because I think I was thinking like if someone filed the petition and then was transferred, the jurisdiction might have shifted between the filing and the appointment.
It could. That could happen. So I guess maybe instead of asking that way, asking like status of, which prison they're in and where they filed from.
Incarcerations, current place of incarceration, and place of incarceration at the time of filing. How about that?
Yeah.
Okay. Anything else that you want to be sure cover evidence-wise in the initial interviews?
That's pretty much it for the first big interview. That'll take you pretty far.
Great. All right. This is generally pulled from some of the other, I can't remember if I pulled it from the criminal or the dependency standards that we've been writing, but consider whether to interview potential witnesses, adverse, neutral, or favorable. And when new evidence is revealed during the course of witness interviews, lawyers should locate and assess its value to the client. Witness interviews should be conducted by an investigator or in the presence of a third person who will be available if necessary to testify as plaintiff's witness at trial. And then duty to comply with the Oregon rules of professional conduct and statutory victims' rights, which is that ever a thing in the habeas context?
No.
Okay. I didn't want to just take it out without asking, but I didn't think it was.
For sure.
Okay. So it sounds like in addition to the interviews on witnesses, we might add something about document review.
Yeah.
Players should carefully review all documents received as or discovery. I'm going to fill in with language similar to 6. So I want to fill in the consider their value to the client language, follow paper trails as needed, and be able to reassess if there's anything else they should be looking for to that. But other than that kind of stuff, is there anything else you're looking at documents for?
Everything.
Yeah.
You want to, is this where a document section should go? Because this can be expanded.
Sure.
Okay, so the struggle with DOJ, and you're going to get most of your discovery from them, from DOJ represents DOC, of course, is that things will be, they will
we do
not
actually
just,
have a, sorry, we do have a specific discovery section that
Oh,
we can
okay,
also put that
okay.
in. This is the, when you get, at least the way I was thinking of it, this is the, when you get documents, what are you doing with them?
Okay,
As opposed to how to get them and where.
got it. I would add to this, you want to have a system of organization starting from the beginning so that you can review the documents easily later, as easily as possible later. Because it's going to be, there's going to be potentially thousands of pages of documents. So if you don't have like just a simple, the simplest system set up, it's just going to be overwhelming when you need to get to them.
Got it. Organization. And that organization and note taking. I assume you are taking notes on what you're reading for review later on.
Mm-hmm.
Okay. Well, we're talking about the investigation side of it. Anything else that you think we should add in on the document review? Review all the things.
I don't know if what I do is what should be considered the standard, but it's really effective. My investigator, so I'll just throw it out there. If it's too specific and not appropriate for this, you can just say so. But my investigator makes this compendium of evidence in like a grid so that we can all access the evidence in the case. And it is painstaking work, but it's the kind of thing that is like the baseline for all litigation, because you are referring to this enormous sprawling documentation. And to create something like a catalog system, some kind of system of cataloging what you're going to need, so you can use it throughout the life of the case, like bookmarks or whatever. I mean, the investigator I work with is really unusual. I don't think most people would stand to do what she does or could, maybe. I don't know if I could. But yeah, it's something like that.
Okay.
Because if you don't, it's going to just blow out of proportion. And if you don't have a way to like break it up for review, it just gets out of control.
How's that? Lawyers should create a system for organizing or cataloging documents and note taking at the beginning of their case to facilitate document review throughout the case.
Yeah, that's broad enough and we'll get folks on the right path.
Great. All right. I did 6. Lawyers should attempt to interview all corrections staff involved in the case, should pursue formal and informal discovery with authorities as described in the discovery standard later on. Are you guys looking to interview DOC staff
No, you
generally,
actually
or is that?
you can't do that because they're represented parties. That's the defendant.
Okay.
So you can't interview anybody from DOC. Or you get in trouble.
Oh, that's a bummer. All right. Well, we will pull that section then. We don't want to get people in trouble.
Yeah.
Obtain all relevant prior records of the client and witnesses, including criminal, juvenile, disciplinary, education, mental health, medical, drug and alcohol, and immigration records where appropriate. Is immigration records ever something you all are looking at? I
Yeah.
couldn't think of a reason, but again, I didn't want to pull it without.
I would take out criminal, juvenile, unless it's relevant, and immigration records. Juvenile might be relevant, but not in every case.
Are the criminal and juvenile records generally relevant enough that we should leave them in as a prompt, or just so few and far between that it's not really worth mentioning?
I have never gotten criminal records. They're just not
Okay.
relevant to conditions. They could be relevant, though, to sentencing. So for that purpose, actually, that could be relevant.
Yeah.
Ed,
All right.
you've done some sentencing cases, right?
I haven't. My stuff has all been conditions, but it's gone beyond medical. But I haven't done anything that was like the basis of confinement.
So maybe keep those in there because, yeah.
Yeah. And use or treatment to drug and alcohol, because drug and alcohol records seems weird. Will stand alone.
Yeah.
Just the phrasing seemed off.
Yeah.
Lawyers should always consider whether to reduce investigation to writing, and should instruct investigators to only reduce investigation to writing after consultation with the lawyer.
Definitely
For
a
those
basic.
cases, lawyer may not intentionally destroy evidence in a case and must comply with all statutes governing discovery to the, there's that, to defense. There is no prosecution. Really thought I caught all those copy paste errors. Always one more. All right. Use of experts. Or sorry, anything else that we want to talk about when we're talking about investigation?
I think that's pretty coherent.
Great. Okay. Lawyers should immediately and continually evaluate the need for experts in the case and should obtain any necessary expert for either consultation or testimony or both. Be aware of the available types of experts that may be needed to properly litigate their case. And a lawyer has a duty to be familiar with the process to request funding for experts from OPDC. That's your baseline standard for use of experts. How does that sound?
Sounds good.
Okay. Consider using an engagement letter for experts. Be aware of the appeals process in the event that OPDC denies funding the lawyer believes is reasonably required for the case. Um, so this is one that I wasn't sure if it was worded particularly well. Lawyers should be familiar with the available experts in all fields likely to arise in habeas and should have available professional network to assist in evaluating and obtaining needed experts. So what I was going for with that was you should know how to find the individual person that you need, whether that's you know them or you have a network of professional contacts who can refer them to you. I'm hoping that's what that actually says.
Even if what you're saying, Jordan, is a lawyer should not accept appointment on a case without an available expert.
I don't know that that's what I was saying. I think you can accept appointment on a case if you don't have an expert, but you have the ability to, locate an expert with reasonable speed.
If you say, yeah, no, I agree. That's more the issue. But I guess access to experts, because there are certainly fields where you're not getting people who will work for what OPDC is going to pay. So I don't want to put words in your mouth, but I think that's kind of what I thought of when you said that is like, you're going to take the case, you need to be able to have the expertise to do it, or have the available expert to do it.
Yeah, I mean, I think what we're saying is if you're going to take the case, you need to either be familiar with the experts that you're going to need or be familiar with the way to find the experts that you're going to need. So it's not like I've never had a case on, I don't know, some Guillain-Barré syndrome and DOC conditions related to that. I don't know who the expert on Guillain-Barré is, but I do know these three people that I could ask, and one of them would know, and that's fine. Does that make sense?
Mm-hmm.
Okay.
Yeah, but I think even if you said lawyers should be familiar with the expertise needed, a lawyer can become familiar with the expertise needed, right? But that's what you have to be able to determine what expertise is needed and know how to obtain or retain that expert.
Yeah.
Okay. So
go ahead.
I would say familiar with the available expert witnesses or consultants in all fields.
I'm having an issue with that sentence because it supposes a lot. First, there could be just any number of issues in habeas.
Yeah.
There's a billion trillion issues in habeas. So I would rephrase it like a lawyer should be ready to and able to obtain an expert for the habeas claims and be aware of how to seek one, something like that. I mean, OPDS has a expert list, which has been very helpful to me on occasions. And it takes a long time to really build an expert pool. I mean, it really does. And it is very hard, as Ed said, to get people just, number one, to go to bat for a prisoner. Number two, to get paid like, pennies to the dollars that they can usually make. It's just a very unusual, it's hard to find experts. So, but I think it's really important, and every case pretty much that I have has an expert, at least one, sometimes up to three.
Mm-hmm.
But it does take development. I think this is something OPDC could do, is to develop a pool of experts specific to habeas and help people to find those folks, or just, something along those lines, because it really is hard if you're just cold calling people. I mean, I've done that and I've found people that way, but I think the main thing is you have to have experts, and you have to be willing to do everything you need to and can do to get them.
How about that? Lawyers should be prepared to obtain experts in habeas claims and should be aware of how to seek needed experts if the lawyer does not have one readily available. Lawyers should be familiar with the process of obtaining a list of experts in a given field from OPDC.
Yeah, that's great.
Okay. And that say what you think we want to say?
Yeah, I thought you might have had something in the initial statement about essentially being able to determine what expertise is needed, but I mean that's kind of part and parcel to every area of practice of law, right? Like you don't take it on if you're not competent, figure it out. So I don't know what you could really say about it.
Yeah, I mean, the initial bit we have the lawyer should immediately and continually evaluate the need for experts in the case. So I think that's covered. This is more just the lawyer should know how to find, like, if I need a doctor for this particular issue, I know how to find a doctor for this particular issue.
You know what OPDC could also do is facilitate a listserv for your habeas practitioners with contracts.
Okay.
That would be incredibly useful because we don't get to talk about what is going on in our cases otherwise.
Hold please. I'm gonna make a couple of notes about that somewhere else.
Great.
Facilitate a list of experts in habeas cases and make inroads with those experts. Facilitate a serve for habeas practitioners to discuss contract work experts ability, etc. All right, I will bring those up. I can make no promises about what the agency will or won't do with them, but I'll push them forward.
That would be great, particularly since there's no training really. At least
we're working on that.
People could talk with, others at least with more experience in that context.
Mm-hmm. Yeah, and we are working on the training for all areas of practice, but
I will help.
I know you will. When we get to the actively working on stage, you will get a phone call.
Cool.
Ed, you're welcome also, but I didn't want to leave you out.
Hey.
All right. Lawyers should independently evaluate the quality of an expert prior to engagement and should consider any evidence that would be available to the defense to impeach that expert. Lawyers should review this evaluation regularly, even with often used experts. Lawyers should understand the difference between an expert used to advise the plaintiff's team and an expert used to testify, and how to assure that an advisory expert does not unintentionally shift to a testimonial expert and require disclosure to the defense. I assume that's still a thing.
It's a thing.
It's a thing in the criminal context. So,
Mm-hmm.
And then lawyers should adequately prepare all experts for testimony, including likely questions on cross-examination.
Yep.
Anything else y'all think needs to be in the how to work with experts section?
I think it's there, but just that you can't, to my mind, you can't overemphasize the need for attorneys to realize they need experts and not, attorneys are not experts and can't testify. Like, And I don't think you can even work up a case. I know you can't without an expert. I get my experts involved and they do interviews fairly quickly with the case, with the client. And I get that their opinion for the very first pleadings straight out of the gate. So we know what their claims will be and what they can be, what are viable claims. I don't know that, and no attorney does. So I just think that's really, really important to get experts in as quickly as possible.
Attorneys should not overly rely on their own knowledge of a given subject and should use experts to offer testimony as needed to prove their case.
I would say to offer consultation as early in the case as possible, and then testimony.
Offer testimony. How's that?
Good. Add after consultation on viable claims, on viable medical claims especially, or just on viable claims, on viability of claims.
Oh, consultation on viability of claims. Gotcha.
Yeah.
There we go.
Great.
All righty. Anything else in the expert section?
Looks good.
Great. We got a nice little clip. Next time we will talk about discovery.
Okay.
Make that blue so we know where to pick up next time.
Cool.
All right. Thank you all for your time on this. I really appreciate it. And I will see you all next time.
Great. Bye.
Thank
all.
you.
Bye.